My understanding is you have an agreement or an announcement to make on the Brown.
We don't have necessarily an agreement or announcement, Your Honor, but I will explain what's going on. On Monday, Ms. Roberts and I were in agreement that we were going to try and find a resolution to this case. Ms. Roberts has conveyed to me just now her proposition for the resolution in this case. I'm not going to be able to discuss that with my client and get it resolved today, as he is coming across country with an RV because he currently has nowhere to live. The wife has kicked him out of the home. So I'm going to make a verbal motion to continue. It seems like y'all got plenty to do today anyway, so that I've got some time to discuss the proposition with my client. Also, Your Honor, I have not been able to file an income and expense statement or an asset and liability statement because of communication issues with my client, which I do think that I have been able to resolve, and I don't believe that we have the same from Ms. Roberts either.
I have mine ready to submit.
Well, it sounds like to me, from what I'm told, that Mr. Van Voort, in your case, is going to take most of the day, and then after that, I have a case that's behind that, the Smithson versus Dixon, that has a number of motions. So it doesn't sound like we're going to get to your case.
Your Honor, the only thing that I want to put on the record and make sure is that this is a situation on where we had filed the divorce because there's some significant issues. It hasn't risen to the level where I felt it was appropriate to get an ex parte restraining order, but it could rapidly get that way. We appeared on Monday, wherein my client, the testimony would show that my client had said that her husband, Mr. Brown, had left and gone to South Carolina to be with his brother, and was continually texting and contacting and emailing about his mental state, and that he didn't know what he was going to do. He has some significant mental health issues that he manages rather than by conventional medicine, by the administration of illegal drugs, and self-medicates himself. Parties have an 11-year-old child. And so it's a scenario where he had not been in town, and as I understand it, had not been in communication with his attorney to get ready for the hearing. We passed it to today. I was in court on both Tuesday, Wednesday, and Thursday of this week. So again, Ms. Jackson Smith and I were not able to discuss resolving the matter. But again, and then as I understand it, Mr. Brown drove with his mother to Colorado and is bringing an RV home to live in. So it's a scenario where it could escalate pretty quickly. If Your Honor's inclined, because again, time constraints, I understand that if Your Honor's inclined to grant this continuance, what I would ask is that Mr. Brown be ordered to submit himself to an extended panel nail bed test between now and a certain time. I give him 36 hours to go and complete that. I don't know what time he plans on arriving back from Colorado.
I have not heard anything in this case up to this point, correct?
No, sir, Your Honor.
When's your next chancery day? On what?
That's next Tuesday. It's because I have to be in front of you in Ashland City on Monday, here on Tuesday, and then back in front of you on Wednesday.
Again, Judge, I don't know that I can get it done that fast.
All right. What's your next day after that?
11/6.
Should be able to do that.
11/6.
Judge, I apologize. I left my calendar in.
All right. I tell you, you're not in front of me because I start the State versus Cordarius Godwin rape trial on the 6th here in Charlotte. So.
I don't, and that's a Judge Lockhart MASH day again. But that's also a Wallace day and a Turnbow day in another county. That's the only thing I'm here on 11/12.
I'm here on a criminal trial.
Well, if you're here on a criminal trial on the 12th, it's not going to be possible for you to hear this case,
I
right?
think it would.
Oh,
think it
that,
would
I
be
knew
interesting, Judge.
I knew I had something on the 6th, Judge, I'm having eye surgery. So I knew I had something going on. That's next Thursday, and I'm having eye surgery, and I won't be able to see for approximately 3 to 4 days.
After the 12th.
We have Marlin versus Marlin on the 25th of November. And is that expected to last all day?
It's a contempt on failure to pay alimony and their counter petition to modify alimony.
I mean, that's you and
And Mr.
the
Bates.
case I'm hearing, and Doug Bates, the 17th, and
I mean, I don't mind putting it on that day.
I fly out that day.
Roberts.
I'm looking, Judge, I'm sorry. I apologize, I didn't get done in court over here until after 5 yesterday, and I left my calendar in my car with my other bag that I didn't go back to
Well,
the
double check
office.
on, if you need to
So,
go out to your car to check it, that's fine. My only thought would be, it sounds like that's probably the first day we can give you. I am going to grant your continuance because it's unlikely that, this was not a regular chancery day that I had assigned on my schedule. I gave it out in a lapse of judgment on my part to, because I thought, that there were some things that needed to be heard. So we just concluded a multi-day criminal trial yesterday yesterday afternoon. This case is the last on the docket, so I'm going to bump it to that December the 3rd. Is that what it was?
Yes, sir, Your Honor.
December the 3rd.
I think I've got to be here on a Mangrum final hearing. So, I'm
All right,
sorry.
then that settles it.
Yes, sir.
December the 3rd. In the interim period, both parties are going to submit themselves to an extended panel hair follicle. I have no evidence before me other than argument as to the fact that there's any drug use. So
That's great.
what's good for him is good for her. We'll order that both of them undergo
Can we do a nail bed test, Your Honor?
whatever test that is requested, nail bed test, and that will be within the next 48 hours.
In 48 hours.
Judge, is there any way that we can get it 17th? We can at least get it to Monday? Because it's Friday, it's Halloween.
That's true.
We got Saturday, Sunday.
Close of business Monday,
Close of business Monday.
the 3rd of November
Yes, sir.
at 6 p.m. Have the test performed by that time.
I'll do it. Thank you.
Ms. Roberts is going to draw the order.
Thank you, Your Honor.
All right.
Thank you, Your Honor. And Mr. Brown, I'll be in touch, okay?
And we are ready to take up the Ferguson. I'm sorry. Yes, sorry. You and Mr. Odom were sitting there so quietly, I hated to even mention it. So. All right, page 4, in the matter of Kaz Alexander Bird. This is a motion to discontinue visitation and set a final hearing.
It is, Your Honor. The minor child has, number one, the mother has not been really attending visitation much and makes excuses as to why she can't be there. She's currently got several more criminal charges while this case has been pending. She's been aloof about it. Additionally, the child gets sick after every visit. So they're having to take the child to urgent care or to the doctor, and the doctor has asked that these visits stop also. You know, that's not necessarily here or there, but the mother has a history of drug abuse. They have smelled alcohol on her at the visits, and frankly, she's not here today, so we're asking that this court grant us the ability.
You
for-
represent her, Mr. Odom?
Judge, I'm appointed to represent her. I'm not 100% certain what happened, Judge, but we received this motion to set. It was styled motion to set in a letter. It had a motion to set and discontinue visitation with it. I came here this morning believing this was just a motion to set. It was on my calendar as a motion to set. Ms. Honeycutt, a few days after, who represents the father, had sent out an email saying she couldn't be here and asked for alternative dates. But there's no record in my file where we forwarded this to my client. And I don't know that she knew to be here. I know Ms. Duke says that she included Ms. Bird on the certificate of service. I've talked to my assistant about it this morning after I realized there was more than just a motion to set on the docket, and she can't recall forwarding it. But it would be our practice at our office to forward these type motions with a cover letter to our client, and that is not in the file. The last email communication in our records are the one from Ms. Honeycutt, probably around October 7th or so, about the same time this would have been received in the mail. But I did try to call my client this morning. It goes to a disconnected number. The call wouldn't go through. And so that's my circumstances, Judge. I asked that the motion be continued to one day next week to give me an opportunity to probably go to her residence and try to find her. And right now, Judge, she has supervised visits. That's all she has. This is not unsupervised visitation. It's supervised.
If I may briefly respond.
You may, I also want to hear from Ms. Smith.
Oh,
She's the guardian
Ms.
ad
Smith.
litem, correct?
She is, Judge.
Well, what I know is what I've been told, and I actually have been involved with this case. I was a guardian ad litem in the dependency and neglect case, and I know Ms. Bird has always been, during the pendency of that, a little sketchy, and that's what I know. But I
I
definitely,
think sketchy is a legal term, if I recall my Black's Law Dictionary, so.
well, just look it up. But anyway, so like I said, I know what I've been told. I don't doubt that she's missed visits. She did that in the dependency neglect case.
Are you, well, number one, I'm hesitant to suspend all contact between the mother and the child or children without some sort of evidence being
Right.
presented to me. Are you prepared to do that today?
We are prepared to do that today. I am sympathetic to Mr. Odell's position on this regarding whether or not his client received notice. But I will say, based on the fact that the mother's phone is disconnected and I sent notice to her last known address, I do that in any case that's ever been with the Department of Children's Services because that's what the department does. We are prepared to move forward today. I am sympathetic.
When is she scheduled to have another visit?
My clients offered her Saturday at 5, and she has not opened or responded to that email or text, I'm sorry.
What do you have available next week? 11/2 is Sunday. Is that okay with y'all?
11/6.
Oh, 11/6? Speak up. What about 11/6?
You have a TPR, where is it here? Facing other criminal charges, she's got criminal court that day.
Anything else?
I've got to be in 2 other courts already that day. Humphreys County's got criminal docket and Hickman's got chancery.
Hopefully
11/4. Yeah, 11/4 would be fine. 11/4, okay.
So 11/4, you could be here in the morning. So y'all are just going to tell the judge, whoever the judge might be, you're just going to insist that that judge take the matter up very first thing, correct?
Yes, I'm sure.
I'm
sure.
going to set it, I'm going to continue this, but I'm going to put an order down that the visitation is suspended until that hearing. And I only do that because obviously if there's some allegations made that I haven't heard any proof on, I want to give the mother an opportunity to be heard and to respond and to be here to hear that. But in the meantime, protection of the minor child or children would behoove me to go ahead and suspend the visitation since it's only next week. So we'll just suspend the visitation until that hearing at 9 o'clock on the 4th of November.
And I'll have my clients reach out to her, and I'll have, I guess, Mr. Odell will reach out to her anyway.
Right now, but I'll go to the last race.
All right.
Thank you, Judge.
I mean, you're going to have to find some way to get in touch with your client if her number has been disconnected, but,
I have the address.
well, I'm continuing it out of an abundance of caution for the mother's protection, but in my opinion, she is entitled to this continuance, but, you know, it'll be up to the next judge as to whether or not it goes beyond that, because at some point, her responsibility is to stay in touch with her lawyer, so. All right, that's fine, thank you. On this one?
Really, the crux of the case is submitting all of her criminal convictions, so that we can go through that.
This is a termination of parental rights.
Yes, Your Honor.
Does he have a lawyer? Has he?
He does. Ms. Honeycutt. I told her I would text her any dates we got.
Who is that?
I can do the 6th. Is there another date after that? Is there a date in March? The 5th and the 6th both work for me. Okay. March the 6th. I'll text you.
March 6th?
Uh-huh.
You know what that day is, right? Why do I continue to try to educate you all of you lawyers about certain historical days?
I do know that date, though.
Yeah, then what is it? Not the Ides of March. It's March 6, 1836,
You're
the
right.
day the Alamo fell in San Antonio, Texas. So I always thought that my namesake, or that I was named after David Crockett. And so I've always had a love for history, and I've been to the Alamo in San Antonio several times. But the fact of the matter, my mother somehow thought mistakenly that I was named after David in the Bible, but I know it was after David Crockett because Fess Parker was playing David Crockett on Disney while I was a child, so I knew that was why I was named that. So
That's perfect, Judge.
I'm sure it is.
This case ends exactly where courtroom tension peaks, not with a final ruling, but with a judicial warning shot. The judge made it crystal clear, allegations alone don't win cases, but risk to a child and instability between parties will never be ignored. Faced with claims of mental health struggles, self-medication, and escalating behavior, the court chose balance over bias. Instead of siding with one narrative, the judge imposed equal accountability, ordering both parties to submit to extended drug testing. That decision alone speaks volumes. This wasn't just about a divorce, it was about control, credibility, and containment. The judge recognized that this situation could spiral fast, and the courtroom became the pressure valve. By granting the continuance but attaching strict conditions, the court effectively said, "You may leave today, but this issue is far from over." What makes this case powerful is the restraint. No shouting, no theatrics. Just a judge quietly asserting authority and drawing a hard line before chaos takes over. December 3rd isn't just another court date, it's a checkpoint, and depending on those test results, everything could change. If you think this ends here, you haven't been paying attention, Yang, stay tuned, because courtroom calm often comes right before the storm.